Florida vs. Royer within Stop and Frisk, Chapter 3 of Crim Pro. This is a 1983 case. Justice White announced the judgment of the court and delivered an opinion in which Marshall, Powell, and Stevens joined after purchasing a one-way airline ticket to New York City at Miami International Airport under an assumed name and checking as 2 suitcases bearing identification tags with the assumed name. Respondent went to the concourse leading to the airline boarding area where he was approached by 2 detectives who previously had observed him and believed that his characteristics fit the so-called drug courier profile. Upon request but without oral consent, respondent produced his airline ticket and driver's license, which carried his correct name. When the detectives asked about the discrepancy in names, respondent explained that a friend had made the ticket reservation in an assumed name. The detectives then informed respondent that they were narcotics investigators and that they had reason to suspect him of transporting narcotics. And without returning his airline ticket or driver's license, asked him to accompany them to a small room adjacent to the concourse. Without respondent's consent, one of the detectives retrieved respondent's luggage from the airline and brought it to the room. While he did respond to the detective's request that the consent to a search of luggage, respondent produced a key and unlocked one of the suitcases in which marijuana was found. Then respondent said he did not know the combination to the lock of the second suitcase, but did not object to it being open. The officers pried it open and found more marijuana. Respondent was then told he was under arrest following the Florida trial court's denial of pre-trial motion to suppress the evidence obtained in the search of the suitcases. Respondent was convicted of felony possession of marijuana. The Florida District Court of Appeals reversed, holding that respondent had been involuntarily confined within a small room without probable cause, that at the time his consent to search was obtained, the involuntary detention had exceeded the limited restraint permitted by Terry v. Ohio, and that such consent was therefore invalid because tainted by the unlawful confinement. So that's our holding. I'm reading it one more time because I feel like there's some new concepts here. Held that respondent had been involuntarily confined within the small room without probable cause. That at the time his consent to search was a voluntary detention had exceeded the limited restraint permitted by Terry v. Ohio, and that such consent was therefore invalid because tainted by the unlawful confinement. Some preliminary observations are in order. First, it is unquestioned that without a warrant to search Royer's luggage and in the absence of probable cause and exigent circumstances, the validity of the search depended on Royer's purported consent. Neither is it disputed that where the validity of a search rests on consent, the state has a burden of proving that the necessary consent was obtained and that it was freely and voluntarily given, a burden that is not satisfied by showing a mere submission to a claim of lawful authority. Second, the law enforcement officers, so I feel like they're pulling out the material facts. This was the appeal court holding. Second, law enforcement officers who do not violate the Fourth Amendment by merely approaching an individual on the street or in another public place by asking him if he is willing to answer some questions, by putting questions to him if the person is willing to listen, or by offering in evidence in a criminal prosecution his voluntary answers to such questions, nor would the fact that an officer identifies himself as a police officer without more convert the encounter into a seizure requiring some level of objective justification. The person approached, however, need not answer any question put to him. Indeed, he may decline to listen to the questions at all and may go on his way. He may not be detained even momentarily without reasonable objective grounds for doing so, and his refusal to listen or answer does not without more furnish those grounds. if there is no detention, no seizure within the meaning of the Fourth Amendment, then no constitutional rights have been infringed. Third, it is also clear that not all seizures of the person must be justified by probable cause to arrest for a crime. Terry created a limited exception to this general rule. Certain seizures are justifiable under the Fourth Amendment if there is articulable suspicion that a person has committed or is about to commit a crime. So third is an exception. I don't know what really the second point stands for. These are just case law rules. They're setting the foundation. So, Royer does not suggest, nor do we, and this is after a ... probably footnote where we go into Davis versus Mississippi of 1969. Talking about when probable cause isn't necessary, in other words. So after the ... Royer does not suggest, nor do we, that a similar rationale would not warrant temporary detention for questioning on less than probable cause where the public interest involved is the suppression of illegal transactions in drugs or of any other serious crime. Fourth, Terry and its progeny nevertheless created only limited exceptions to the general rule that seizures of the person require probable cause to arrest. Again, it's a limited exception. Detentions may be investigative, yet violative of the Fourth Amendment absent probable cause. In the name of investigating a person who is more than suspected of criminal activity, the police may not carry out a full search of the person or of his automobile or other effects, nor may the police seek to verify their suspicions by means that approach the conditions of arrest. Dunway versus New York made this clear. Hope so. There, the subject was taken to the police station from his home and, without being formally arrested, interrogated for an hour. The resulting incriminating statements were held inadmissible. Reasonable suspicion of crime is insufficient to justify custodial interrogation, even though the interrogation is investigative. That's clear. There, the suspect was taken to the police station from his home and, without being formally arrested, interrogated for an hour. The resulting incriminating statements were inadmissible, resulting in a reasonable suspicion of crime is insufficient to justify custodial interrogation, even though the interrogation is investigative. It is kind of relevant considering facts of this case. There's still quite a bit of this majority opinion to get through, but United States versus Sharp is a footnote case. I'll just read what's highlighted here. The fact that the protection of the public might, in abstract, have been accomplished by less intrusive means does not in itself render the search unreasonable. Terry is discussed. U.S. versus Hensley, 1985. The circumstances must have justified the length and intrusiveness of the stop. Like that. Considering the Hebelt case. Don't know where that came from, but there's Hayes versus Florida, a similar limitation, and Illinois versus Caballes, and 2005 case. A drug dog came for just a regular traffic violation and discovered marijuana. Full search. Okay. After the dog alerted. So, a minor traffic violation. In Hayes, detention for fingerprinting would be permissible only if there is a reasonable basis for believing fingerprinting will establish or negate the suspect's connection with the crime, justifying the stop. Whatever. So the Fourth Amendment's prohibition, back to this case, against unreasonable searches and seizures has always been interpreted to prevent a search that is not limited to the particularly described place to be searched and the persons or things to be seized, even if the search is made pursuant to a warrant and upon probable cause. The amendment's protection is not diluted in those situations where it has been determined that legitimate law enforcement interests justify a warrantless search. The search must be limited in scope to that which is justified by the particular purposes served by the exception. The reasonableness requirement of the Fourth Amendment requires no less when the police action is a seizure permitted on less than probable cause because of legitimate law enforcement interests. The scope of the detention must be carefully tailored to its underlying justification. The predicate permitting seizures on suspicion short of probable cause is that law enforcement's interests warrant a limited intrusion on the personal security of the suspect. The scope of the intrusion permitted will vary to some extent with the particular facts and circumstances of each case. This much, however, is clear. An investigative detention must be temporary and last no longer than is necessary to effectuate the purpose of the stop. Similarly, the investigative methods employed should be the least intrusive means reasonably available to verify or dispel the officer's suspicion in a short period of time. It is the state's burden to demonstrate that the seizure it seeks to justify on the basis of reasonable suspicion was sufficiently limited in scope and duration to satisfy the conditions of an investigative seizure. Fifth, statements given during a period of illegal detention are inadmissible even though voluntarily given if they are the product of illegal detention and not the result of an independent act of free will. Sixth, if the events in this case amounted to no more than a permissible police encounter in a public place or justifiable Terry-type detention, whereas consent, if voluntary, would have been effective to legalize the search of his 2 suitcases. The state proffers 3 reasons for holding that when Royer consented to the search of his luggage, he was not being legally detained. First is that it is submitted that the entire encounter was consensual and hence Royer was not held against his will at all. We find this submission untenable. Asking for and examining Royer's ticket and his driver's license were no doubt permissible in themselves, but when the officers identified themselves as narcotics agents, told Royer that he was suspected of transporting narcotics and asked him to accompany them to the police room while retaining his ticket and driver's license and without indicating in the way that he was free to depart. Royer was effectively seized for the purposes of the Fourth Amendment. These circumstances surely amount to the show of official authority, such that a reasonable person would have believed that he was not free to leave. Second, the state submits that if Royer was seized, there existed reasonable, articulable suspicion to justify temporary detention, and that the limits of Terry-type stop were never exceeded. We agree with the state that when the officers discovered that Royer was traveling under an assumed name, this fact and the facts already known to the officers, paying cash for a one-way ticket, the motive, I agree. There's a lot of things that could have established probable cause here. So checking the 2 bags and Royer's appearance and conduct in general were adequate grounds for suspecting Royer of carrying drugs and for temporarily detaining him and his luggage while they attempt to verify or dispel their suspicions in a manner that did not exceed the limits of the investigative detention. We also agree that had Royer voluntarily consented to the search of his luggage while he was justifiably being detained on reasonable suspicion, the products of the search would be admissible against him. We have concluded, however, that at the time Royer produced the key to his suitcase, the detention to which he was then subjected was a more serious intrusion on his personal liberty than is allowable on mere suspicion of criminal activity. By the time Royer was informed that the officers wished to examine his luggage, he had identified himself when approached by the officers and had attempted to explain the discrepancy between his name shown on the identification and the name under which he had purchased his ticket and identified his luggage. The officers were not satisfied, for they informed him that they were narcotics agents and had reason to believe that he was carrying illegal drugs. They requested him to accompany them to the police room. I'd really be interested if purchasing a ticket in a name that is not one's own is an offense, that could lead to an arrest in and of itself. And then he consent. Anyhow, they requested him to accompany them to the police room. Royer went with them. He found himself in a small room, a large closet equipped with a desk and 2 chairs. He was alone with 2 officers who again told him that they thought he was carrying narcotics. He also found that the officers, without his consent, had retrieved his luggage from the airline. What had begun as a consensual inquiry in the public place had escalated into an investigatory procedure in the police interrogation room, where the police, unsatisfied with nervous previous explanations, sought to confirm their suspicions. The officers had Royer's ticket. They had his identification. They had seized his luggage. Royer was never informed that he was free to board his plane if he so chose, and he reasonably believed that he was being detained. At least as of that moment, any consensual aspects of the encounter had evaporated, and we cannot fault the Florida District Court of Appeal for concluding that Terry v. Ohio and the cases following it did not justify a restraint to which Royer was then subjected. As a practical matter, Royer was under arrest. Consistent with this conclusion, the state conceded in the Florida courts that Royer would not have been free to leave the interrogation room had he asked to do so. Furthermore, the state's brief in this court interprets the testimony of the officers at the suppression hearing as indicating that Royer refused to consent to a search of his luggage. The officers would have held the luggage and sought a warrant to authorize the search. We also think that the officers' conduct was more intrusive than necessary to effectuate an investigative detention, otherwise authorized by the Terry line of cases. First, by returning his ticket and driver's license and informing him that he was free to go as he desired, the officers might have obviated any claim that the encounter was anything but consensual from start to finish. Second, there are undoubtedly reasons of safety and security that would justify moving a suspect from one location to another during an investigatory detention, such as from an airport concourse to a more private area. There is no indication in this case that such reasons prompted the officers to transfer the site of the encounter from the concourse to the interrogation room. It appears rather the primary interest of the officers was not having an extended conversation with Royer, but in the contents of his luggage, a matter which the officers did not pursue orally with Royer until after the encounter was relocated to the police room. The record does not reflect any facts which would support a finding that legitimate law enforcement purposes would justify the detention in the first instance were furthered by removing Royer to the police room prior to the officer's attempt to gain his consent to a search of his luggage. As we have noted, Had Royer consented to a search on the spot, the search could have been conducted with Royer present in the area where the bags were retrieved by Detective Johnson, and by evidence recovered would have been admissible against him. If the search proved negative, Royer would have been free to go much earlier and with less likelihood of missing his flight, which in itself can be a very serious matter in a variety of circumstances. Third, the state has not touched on the question whether it would have been feasible to investigate the contents of Royer's bags in a more expeditious way. The courts are not strangers to the use of trained dogs to detect the presence of a controlled substance in luggage. There is no indication here that this means was not feasible or available. If it had been used, Royer and his luggage could have been more momentarily detained while his investigative procedure was carried out. Indeed, it may be that no detention at all would have been necessary. A negative result would have freed Royer in short order. A positive result would have resulted in his justifiable arrest on probable cause. We do suggest that there is a litmus paper test for distinguishing consensual encounter from a seizure for determining when a seizure exceeds the bounds of an investigatory stop. Even in the discrete category of airport encounters, there will be endless variations in the facts and circumstances, so much variation that it is unlikely that the courts can reduce to a sentence or a paragraph a rule that will provide unarguable answers to the questions whether there has been an unreasonable search or seizure in violation of the Fourth Amendment. Nevertheless, we must render judgment, and we think that the Florida District Court of Appeal cannot be faulted in concluding that the limits of the Terry stop have been exceeded. The state's third and final argument is that Royer had not been illegally held when he gave his consent because there was probable cause to arrest him at the time. Detective Johnson testified at the suppression hearing, and the Florida District Court of Appeal held that there was no probable cause to arrest until Royer's bags were opened. But the fact that the officers did not believe there was probable cause and proceeded on a consensual or Terry-like rationale would not foreclose the state from justifying Royer's custody of proving probable cause, and hence removing any barrier to relying on Royer's consent to search. We agree with the Florida District Court of Appeal, however, that probable cause to arrest Royer did not exist at the time he consented to the search of his luggage. The facts are that a nervous young man with 2 American Tourister bags paid cash for an airline ticket to a target city. These facts led to inquiry, which in turn revealed that the ticket had been bought under an assumed name. The proffered explanation did not satisfy the officers. We cannot agree with the state if this is its position that every nervous young man paying cash for a ticket to New York City under an assumed name and carrying 2 heavy bags may be arrested and held to answer for a serious felony charge. Because we affirm the Florida District Court of Appeal's conclusion that Royer was being illegally detained when he consented to a search of his luggage, we agree that the consent was tainted by the illegality and was ineffective to justify the search, and they're affirming. Now, Brennan concurs, Blackman dissents, Rehnquist, the Chief Justice, and O'Connor dissent. And it's not so much longer, I'll go through it. To the extent that the plurality endorses the legality of the officer's initial stop of Royer, it is wholly unnecessary to reach that question. For even assuming the legality of the initial stop, the plurality correctly holds, and I agree, that the officer's subsequent actions clearly exceeded the permissible bounds of a Terry investigative stop. The scope of a Terry-type investigative stop and any attendant search must be extremely limited, or the Terry exception would swallow the general rule that Fourth Amendment seizures and searches are reasonable only if based on probable cause. In my view, any suggestion that the Terry reasonable suspicion standard justifies anything but the briefest detentions or the most limited of searches finds no support in the Terry line of cases. In any event, I dissent from the plurality's view that the initial stop of Royer was illegal. for plainly, Royer was seized for purposes of Fourth Amendment when the officers asked him to produce his driver's license and airline ticket. By identifying themselves and asking for Royer's airline ticket and driver's license, the officers, as a practical matter, engaged in a show of authority and restrained Royer's liberty. It's simply wrong to suggest that the traveler feels free to walk away when he has been approached by individuals who have identified themselves as police officers and asked for and received his airline ticket and driver's license. Blackman dissenting, in my view, the police conduct in this case was minimally intrusive. Given the strength of society's interest in overcoming the extraordinary obstacles to the detention of drug traffickers, such conduct should not be subjected to a requirement of probable cause. Because the court holds otherwise, I dissent. At the suppression hearing in this case, Royer agreed that he was not formally arrested until after his suitcases were opened. In my view, it cannot fairly be said that prior to the formal arrest, the functional equivalent of an arrest had taken place. The encounter was far more in common with any automobile stops justifiable on reasonable suspicion than with the detention deemed the functional equivalent of a formal arrest in Dunaway versus New York. In Dunaway, the suspect was taken from his neighbor's home and involuntarily transported to the police station in a squad car. At the precinct house, he was placed in an interrogation room and subjected to extended custodial interrogation. Here, Royer was not taken from a private residence where reasonable expectations of privacy perhaps are at their greatest. Instead, he was approached in a major international airport where, due in part to extensive anti-hijacking surveillance and equipment, reasonable privacy expectations are of significantly lesser magnitude, certainly no greater than the reasonable privacy expectations of travelers in automobiles. What followed was within the scope of strict lesser intrusions upon approved on less than probable cause in our prior cases. So the privacy expectations are lower because of extensive anti-hijacking surveillance and stuff. Okay. What followed was within the lesser intrusions and proved on less than probable cause in our prior cases and was far removed from the circumstances of Dunaway. Like Justice Rehnquist, I do not understand the plurality to dispute that Royer consented to go to the police room because the detention up to this point was not unlawful. So this is a plural opinion. The voluntariness of Royer's consent is to be judged on the totality of the circumstances. Now, back to Rehnquist, the Chief Justice and Justice O'Connor. The point at which I part company with the plurality's opinion is in the assessment of the reasonableness of the officer's conduct following their initial conversation with Royer. The plurality focuses on the transfer of the place of the interview from the main concourse of the airport to the room off the concourse and observes that Royer found himself in a small room, a large closet equipped with a desk and 2 chairs. He was alone with 2 officers who again told him that they thought he was carrying narcotics. He also found that the officers, without his consent, had retrieved his checked luggage from the airlines. Obviously, this quoted language is intended to convey stern disapproval for the described conduct of the officers. To my mind, it merits no such disapproval and was eminently reasonable. Would it have been preferable for the officers to have detained Royer for further questioning, as they conceitedly had a right to do, without paying any attention to the fact his luggage had already been checked and on the flight to New York and might be put aboard the flight even though Royer himself was not on the plane? Would it have been more reasonable to interrogate Royer about the contents of his suitcases and to seek his permission to open the suitcases when they were retrieved in the busy main concourse of the Miami airport rather than to find a room off the concourse where the confrontation would surely be less embarrassing to Royer? If the room had been large and spacious rather than small, if it had possessed 3 chairs rather than 2, would the officer's conduct have been made reasonable by these facts? The plurality's answer to these questions, to the extent that it attempts any, are scarcely satisfying. It commences with the observation that the officer's conduct was more intrusive than necessary to effectuate investigative detention otherwise authorized by the Terry line of cases, All of this, to my mind, adds up to little more than saying that if my aunt were a man, she would be my uncle. The officers might have taken different steps than they did to investigate Royer, but the same may be said of virtually every investigative encounter that has more than one step to it. The question we must the question we must decide is what it was unreasonable about the steps which these officers took with respect to this suspect in the Miami airport on this particular day. But since even the plurality concedes that there was articulable suspicion warranting an investigatory detention, the fact that the inquiry had become an investigatory procedure in the police interrogation room would seem to be less bearing on the proper disposition of the claim that the officers violated the Fourth Amendment. By reasonableness of the officer's activity in this case did not depend on Royer's consent to the investigation. Nevertheless, the presence of consent further justifies the action taken. The plurality does not seem to dispute that Royer consented to go to the room in the first instance. Certainly, that conclusion is warranted by the totality of the circumstances. If Royer was legally approached in the first instant and consented to accompany the detectives in the room, it does not follow that his consent went up in smoke and he was arrested upon entering the room. As we made clear in Mendenhall, logical analysis would focus on whether the environment in the room rendered the subsequent consent to a search of the luggage involuntary.